Thanks, Michelle. Appreciate everybody joining us this afternoon for a great course on probate administration. I'm going to kick us off today by talking about some recent developments in the area of decedent's estate administration, including some case updates, some new revised statutes, and then as well as some resources that you can refer to get you started as you begin down the probate process. The first case that I wanted to talk about is Estate of Eimers. And this is a case that deals with the exercise of a power of appointment. Alex, since this is a beginning class, I will provide some underlying information as appropriate. In many cases, the power of appointment is granted to a beneficiary in a trust, which allows them to redirect where their share of the trust estate would go. It's not uncommon for that power of appointment to require that it be exercised in a certain way. And that was the issue that was on appeal in this case. Specifically in this case, the decedent had done a holographic will where in essence he said, I want my share of the trust to go to these people. And the decedent did have a power of appointment under the trust, and the trustee petitioned the court for instruction to determine whether or not the holographic will was an effective exercise of the power. And the trial court determined that it was not, because it did not contain a specific reference to the power of appointment within the trust. And that was a requirement of the power of appointment in the trust. And the Court of Appeals affirmed. Now, the reason why the Court of Appeal confirmed has to do with Probate Code Section 631. And this is something that you may have to deal with if you're administering a will, because oftentimes these powers of appointments are exercised within a will. And Section 631 says that a court is able to excuse non-compliance with the requirements of a power of appointment as long as two requirements are met. The first is that the way that the power was exercised approximates the requirement. And the second is that the failure to satisfy the formal requirements does not defeat a significant purpose of the donor. So it seems like this would be a great case for the court to exercise that discretion and excuse compliance, since it was clear from the power from the holographic will that the decedent intended to redirect his share of the trust. But Section 631B contains a carve-out for the court's discretion. It says this section does not permit a court to excuse compliance with a specific reference requirement under 632. And that's the type of power of appointment that we were dealing with in this case. So the Court of Appeal ultimately held that because 631B says that the court can't excuse compliance, non-compliance, where there's a specific reference power, that it could not reform the trust. Now, from my perspective, this was, I understood where the court was coming from, although it was a little bit odd, because in a petition for reformation, which is what the beneficiaries of the will were asking the probate court to do, the probate court was being asked to modify the will to bring it into compliance with the specific reference requirement. And a petition for reformation is appropriate if there was an error or mistake in the draft of the testamentary instrument, and it's proven by clear and convincing evidence what the testator's testamentary intent was. And there was no dispute in this case that as I said, the decedent was trying to exercise the power of appointment. So I think that if the Court of Appeal wanted to, it could have gone the other way. It could have determined that by modifying the will, the court wouldn't be relying on 631 because it wouldn't be excusing compliance, because by that point, once modified, you would have a power that is in compliance. But ultimately, the court didn't go that direction. They stuck to a strict literal interpretation. So the takeaway is that a petition for reformation is not going to be able to be used to cure a defect in the exercise of a power of appointment if it's a specific reference clause. Our next case is Eiford v. Nord, and this one deals with essentially the validity of a testamentary instrument. In that case, the question on appeal had to do with the trial court not accepting the challenger of in this case it was a trust, their argument that the settlor was suffering from an insane delusion. And I included this case, even though it's a trust case, because it deals with the probate code section on testamentary capacity, which is 6100.5. And 6100.5 provides that an individual is not mentally competent to make a will if at the time of making a will, the individual suffers from a mental health disorder with symptoms including delusions or hallucinations, which delusions or hallucinations result in the individual's devising the property in a way that, except for the existence of the delusions or hallucinations, the individual would not have done. And the argument by the challengers, who were the grandchildren of the settlor, was that their grandmother had several manifestly false beliefs, and those beliefs are what caused her to change her trust to disinherit them. Essentially, the grandmother thought that the grandkids were out to get her money, wanted to kill her, were taking over her life and trying to push her out. And even though the grandchildren were able to show from a factual standpoint that these things were not true, the trial court held that that did not qualify as a delusion, even though the settlor's belief in those incorrect facts is what prompted her to make the change. And what the Court of Appeals settled on most had to do with the requirement under the statute that the delusion or hallucination be the result of a mental defect, as the statute says. And so what the challengers did not do in this case was connect the false beliefs that their grandmother was having to a particular mental defect or mental condition, or as the statute says, mental health disorder. That the mental, or that the cognitive issues they were able to show were not ones that would cause a delusion or hallucination. So the takeaway from this case was that if someone is challenging a will that you're admitting to probate, and the basis for the challenge is that the testator had a false belief, an objectively false belief that prompted them to make the change, you need to make sure that that false belief is the byproduct of a mental health disorder and not just an irrational or improbable conclusion or deduction from what's going on around them. Our third case is the estate of Wall. And the estate of Wall deals with the interplay between several presumptions that may come into play as you're administering a probate. One of those presumptions is the community property presumption found in Family Code Section 760, which provides that assets acquired during marriage, not by gift or inheritance, are presumed to be community property. And the other presumption is the form of title presumption found in Evidence Code Section 662, which, there's this public policy consideration to provide for stability of title. And so there's an evidentiary presumption that the title to assets is presumed to be the true and accurate title. And in this case, in the state of Wall, you had a husband and wife that got married much later in life. And after husband died, wife brought a petition to confirm the home they were living in as a community property asset. And the home was purchased during their marriage. The children of the decedent showed that and argued that the home was purchased with the separate property funds of the decedent. The mortgage payments were made from a bank account in the name of the decedent that has his separate property income, pensions and Social Security that he earned prior to marriage, and that the home was titled in just the decedent's name. And so the Evidence Code Section 662, form of title presumption, is what the trial court should go with. The trial court, though, found that there was a conflict between the Family Code Section community property presumption and the Evidence Code presumption, and went with the community property presumption and found that it wasn't rebutted. Now, on appeal, the appellate court affirmed the trial court's order, but as to this particular issue, the appellate court disagreed with the trial court. And specifically, the appellate court found that the case that the trial court relied on, I think it was the Volley case, there was a concurrence, and the trial court latched onto some language in the concurrence. And the Court of Appeal said, no, that was mistaken. Where there's a conflict between the Family Code and community property presumption and the Evidence Code form of title presumption, the Family Code presumption prevails only in actions between the spouses, such as divorce. And the cases that found that were all divorce cases, although there was a subsequent case where it was a bankruptcy trustee that was involved, but in form, it was an action between parties. And the Court of Appeal then confirmed that when it comes to decedent's estates, the Evidence Code form of title presumption is going to prevail over the community property presumption. Now, this will be important as you're administering estates because it'll come up in several contexts. One is, as you'll learn later, when you're preparing an inventory and appraisal, you'll need to indicate whether assets are community property or separate property. And so based on this case, you will go with the form of title presumption as the default rule, or there may be a spousal property petition, which is an alternative to probate, or a summary proceeding, in which case you have to submit schedules that show what was separate property, what was community property of the decedent, and how should it be devised to the surviving spouse. And so these presumptions will come into play in a spousal property petition and an inventory and appraisal context. The next update I want to address has to do with Proposition 19. I'm sure that many of you heard about Proposition 19. It was obviously on the ballot back at the end of 2020. And Prop 19 repealed portions of Prop 58. And under the old rules, I'm going to use parent-child, even though grandparents sometimes come into play. So under Prop 58, you had the parent-child exclusion. And what that allowed was a parent could leave their tax basis in their principal residence to their children, regardless of value, plus an additional $1 million of assessed value in other property. So if you had a decedent who acquired a home in the Bay Area 40 years ago for, $150,000 and the tax basis was now $250,000. The home was worth $1.5 million. When the decedent transferred the property to at their death, in the context of our discussion today, the children could inherit that $220,000 tax basis and continue to pay taxes on that low basis. It would not be reassessed. On top of that, there was this other $1 million of assessed value that could be transferred. Prop 19 did away with that. So for transfers that occur after February 16th, 2021, there is a new rule. And there is still a parent-child exclusion from reassessment, but the exclusion is limited to $1 million above the current assessed value. So I don't remember the numbers I used in my example, but it was more than $1 million between the fair market value and the assessed value. And so in that situation, I gave an example in the materials of how you calculate it. And there's a step-by-step process that you go through. The key here is that $1 million above current assessed value exclusion is limited to situations where the child must live in the principal residence after the transfer. That wasn't the requirement under the old rule. Under the old rule, the transfer of the principal residence for an unlimited value only looked at whether it was the transferor's or the decedent's principal residence. It didn't matter what the children were doing with it. Under the new rule, at least one of the children has to occupy the residence as their principal residence in order for the exclusion to be available. And as the slide indicates, the $1 million of assessed value of other property is completely gone. So is a pretty big change from the Prop 58 rules. One thing to note is that the transfer date is, in the context of a probate administration, is going to be date of death. So if you get a probate that comes into your office, next week, but the decedent died in January of 2021, the exclusion is still available and potentially, it's potentially on the table. And so you should talk to the client about whether they need to fill out the appropriate paperwork in order to secure that going forward. The other change to the probate code actually ties back into the estate of Wall case about the community property presumption and the former title presumption. Is probate code section 21385. There was another presumption at play in the Wall case, and that had to do with the presumption of undue influence in transactions between spouses, where one spouse gains an advantage over the other in the transaction. In the Wall case, the court confirmed that if the former title presumption trumps the community property presumption, the undue influence presumption trumps, if it's at play, trumps the form of title presumption. Now, this created some potentially sticky situations when it comes to estate planning, as there were prior cases, the Lentz case in particular, where the courts determined that estate planning documents could trigger the undue influence presumption under Family Code section 721. If the estate planning document, essentially created a benefit to the spouse. Maybe it was a transmutation, maybe it was in the Lentz case, it was a a change in the terms of the trust that left a larger amount to the spouse and made them a trustee. And the court found that, yeah, that presumption could apply. Well, Probate Code Section 21-385 was amended to state that an at-death transfer between spouses by will, trust, beneficiary designation is not subject to Family Code Section 721. Now, that doesn't mean that there aren't any other presumptions of undue influence that could apply. There's a common law presumption of undue influence, and there are other presumptions of undue influence that could apply. But this section is only applicable to the Family Code Section 721 presumption of undue influence. So just doing a new will, for example, that leaves all your separate property to your surviving spouse and changes the executor from the kids to the surviving spouse, that's not going to be subject to the presumption of undue influence under Family Code Section 721. A few other notable changes, and I'm going to go back to some rules that came into play back in 2020, given the COVID environment that we were in. And these have to do with the small estate values. The small estate values, which you'll learn more about, I think, in your next section, these were all increased, and they were indexed for inflation going forward. And so a small estate is no longer estates under $150,000. It's now $166,250. We're dealing with real property. That went up by about 10%. And these will be adjusted every 3 years for inflation. Next, I want to turn our attention to talking about useful resources that you can look at to help you get started. Now, I've been doing probate administrations and all things trust and estates for my entire career. And I still go to these resources, especially if I'm in a county that I haven't been in a while. And so I want to kind of go through these and explain why these are great things to look at anytime you're starting an estate administration, especially in a court that you haven't been in a while. The first of these is checking for local forms. Now, not all counties have local forms, especially probate-related local forms, but many do, especially if you're in bigger counties. Now, checking for local forms is easy. You go to the court's website, and usually under online resources, there'll be a tab for local rules and local forms. And you can scan these. Typically, they're sorted by department, and so there'll be probate forms. And scan those for the county that you're going into to see if there are any local forms that potentially relate to the type of proceeding. For example, in Sacramento, there's a local form for a Zoom notice of hearing, which is not uncommon nowadays. And you might not know about that otherwise because it's not going to be in the local rules. It's not going to be in the statute, but scanning the local forms is going to make you see, oh, there's this Zoom notice for probate hearings. That's a mandatory form. And then you can go research further as to what's involved in that. The reason why this is important too is, like in Sacramento, it's a 4-month wait to get a hearing date. And Sacramento uses probate notes that they post about 2 weeks ahead of the hearing. And so if you weren't aware of the requirement for a Zoom notice of hearing and the use of this specific form, about 14 days before your hearing date, you could look at your probate notes and see that the court is missing a proof of service on the Zoom notice of hearing. The problem is you're now outside of the notice period, and you're not going to be able to correct that probate note. And so when you show up after waiting 4 months for your first hearing date, the court's going to continue your matter another 4 months. And so it's now going to be 8 months between the time you initially filed your petition and you're actually ready for the court to hear your matter, even if otherwise you did everything else right. So always check the local forms. Next is local rules. I'm sure you've been told this before. Look at that. Most counties have specific rules on probates. It could tell you how they assign the probate referee, which is something that you'll need to fill out your proposed order in a probate. It could tell you whether or not they set review hearings automatically, both on filing the INA and on the status of the administration. It can tell you what their default rules are for extraordinary compensation or attorney affidavits. You're most likely going to find good information in there that'll be applicable to a probate proceeding. You'll also be able to see, go into the court's website, what filing options you have, whether the court uses e-filing, whether it's mandatory or optional, whether you can begin a probate with e-filing, or you have to file paper first, but subsequent documents can be e-filed. Another important thing to figure out by visiting the court's website is what type of probate notes or tentative ruling system that county uses, and how far in advance they provide those notes. Because the worst thing is to have, a client feeling like everything's teed up, they have confidence in you, they feel like you know what you're doing, and then you show up at the hearing and the court asks you, did you see our probate notes? What's your response? And you have to stand there likely with your client watching on and say, no, I haven't seen it. And the court, instructs you on the defects in the petition. It's much better to be proactive. Hopefully everything was prepared properly and your probate note or tentative ruling is that your petition's ready for approval. But if not, you want to know how soon the court's going to tell you what issues it has with your petition so you can hopefully fix them prior to the hearing date. And you'll usually either see that in the local rules, or oftentimes there's a separate tab on the court's website that takes you to the probate notes and tentative rulings and describes the process. Nowadays, another thing that's important to figure out is, what are your appearance options? Is the county that you're appearing in remote only? Do they have an in-person option? If there is a remote option or requirement, what platform are they using? Are they using BlueJeans? Are they using Zoom? Are they using Court Call? Are they using vCourt? Do you need court permission to sign up for it? How far in advance? Do you have to give notice? And so you'll want to check to see what those are, so that you don't fall into any notice issues, or just not be able to appear at the hearing. Last that I've listed is standing orders. So sometimes, especially related to COVID and the remote appearance options, there's going to be standing orders for a particular county or for maybe just a department that says, you don't have to file a request for telephonic appearance right now. Until further notice, we're waiving the requirement that you have to file paperwork for permission to appear telephonically. You can just do it automatically. And so check to see if there's any standing orders that are applicable to your matter. The next section that we're going to talk about has to do with the forms that you're going to be using. A good way to acquaint yourself with the probate process is to go look at the Judicial Council forms. You can go straight to the Judicial Council website. You can sort them by category and pull up the probate-related forms, and they'll then be listed by form number. A couple of things about the Judicial Council forms that you may or may not know. One is sometimes the form numbers themselves are helpful to letting you know how the forms are related to one another. Two is in the lower right-hand corner of the judicial counsel form is usually a citation to, in this context, particular probate code sections or rules of court that point you to the legal authority that the judicial counsel used in developing that form. So if you have a question about how you're filling out the form or whether you need to fill out the form, oftentimes a good starting place is to look at the statutes that the form references. They're counting them as like enabling statutes for this particular form. And that might be able to cue you in to how this form is used or what's supposed to go on this form. On the lower left-hand corner, the form will tell you if it's optional or mandatory. Obviously, if it's mandatory, you must use that form. And if it's optional, most of the time it's a good idea to use the form unless there's some reason to depart from it. Again, local rules may tell you to use an optional form and make it less optional. So keep an eye out for that. And finally, I can't stress this one enough. I highly, highly recommend that you, especially if you're going to be doing probates on an ongoing basis, you find a good form filler. One of the ones that's been around the most is Essential Forms. That I believe was bought out by CEB several years ago. And the other is Lexis. I personally use the Lexis one. These are great because, for example, with any probate, you're going to have at least 5 or 6 judicial counsel forms just to get the ball rolling. And rather than have to manually type in your name, your address, your phone number, your email, the caption name, the case number, the form filler will automatically populate that across all your forms. With Lexis, I can speak to that one a little bit better. Essentially, by filling out the petition for probate, it will automatically populate all those other 4 or 5 forms because the information that goes in those 4 or 5 forms stems from the information you put into the petition for probate. And so you can save a lot of time, and you can also cut down on mistakes if you use some sort of form filler. Finally, practice guides. I use practice guides every day. The amount of information that is required to be in your head to do a probate is immense. And so having ready access to a practice guide is key to avoiding mistakes. The CEB practice guides, anybody who practices in this area will tell you are the gold standard, much more in depth than any other publisher that I've come across. And they have multiple practice guides just related to probate administration, let alone estate planning, trust administration, and some of the other more nuanced areas in trusts and estates. These 5 practice guides here would likely fill an entire, bookshelf. If you don't want to pay the, whatever it is, $1,500, $1,700 a year to get the estate planning library, most law libraries have a CEB subscription that you can access, or a LexisNexis or Westlaw if you want to go with those ones. To answer, I think the only question that I see right now, Kathleen asked, what happens to assessed value over $1 million going to Prop 19? So if you look at the notes that are included in your handouts, the market value, so once you add the current assessed value plus $1 million, so let's make it easy. Let's say assessed value is $250,000 and market value is $1.5 million. So we would add $1 million to the assessed value of 250,000, which gives us 1.25 million. There is now a difference of $250,000 between that number and the current market value of 1.5 million. So you add that difference to the current assessed value, which would give you so you have original assessed value of 250, a difference of 250, and so your new assessed value would be $500,000 on that $1.5 million market value of property. And that's laid out in detail in the written materials. The other question is, for the $15,000 related to a paycheck, is this the amount of the last paycheck without being part of the probate estate? The answer is yes. Those numbers all relate to summary probate administration procedures. So the ability to collect assets without having to go through a formal probate administration. Now, if a probate administration is otherwise required, you can't use the summary procedure just to collect that specific asset. And the Probate Code 13-100 statutes describe that. Essentially, you'd have to have the consent of the personal representative to fill out the declaration or affidavit you need to collect those funds. But if you have a probate going, that last paycheck would ordinarily become part of the probate estate and be inventoried and accounted for as part of the probate administration. And I'm sure that the next presenters will go into more detail about some of those administration procedures. So if there are no other questions, that is the end of my time, and I will turn it back over to Michelle to introduce our next presenters. Thank you.
And thank you so much, Brian. I really appreciate you taking the time to be with us and also answering the questions. And we hope to see you again. Thank you.
So you're at the stage of the estate administration where you have signed up a client and they come into your door and you're meeting with them and you're gathering information. And this initial step in every estate administration is, what are the documents provide? Most particularly the estate planning documents. So first of all, get the death certificate. That's without a doubt. The family members should be able to access those through the LA County Recorder's Office or the Vital Records Office. You're going to need certified copies for several reasons that we'll discuss in our presentation. But most importantly, we need to know, what are the estate planning documents? Is there a will? What are the assets? What are the title of the assets? Are there any financial accounts? Are there any real property assets? Who's in control of them? All of those initial things we're going to have to do. And where you locate these documents is ask friends, ask family, ask business advisors, ask attorneys. If you know the decedent's estate planning attorney, reach out to them. Hopefully, the decedent gave a copy of his or her estate planning documents to his or her named personal representative or trustee of his estate. But if not, there's no public record of these documents. You're just going to have to track them down by asking family members and friends. Another way you can access these documents is through the safe deposit box. There's a Probate Code Statute 331 that we've cited in our material that allows you to access safe deposit boxes for the sole purpose of trying to find estate planning documents without starting probate. So this is pre-estate administration. It gives you the ability to do that. A general note, power of attorneys are no longer able to be used upon the death of the principal. Power of attorneys expire, and then the probate court's estate administration kicks in, and you have to get the court's authority to be able to continue to act on behalf of the decedent. Slide 6 or 26. Nope, not there yet. It's the last one. So as you're looking for the estate planning documents, obviously you're going to ask for the will, but you're going to need the original will. It's one of the very few things in the probate court where you still need originals, and copies are usually not sufficient. So track down the wet signature, and the personal representative of whoever is in possession of the will has 30 days from the date of death to bring the original will to the court and lodge it. And in addition to that, mail a copy to the named personal representative of the estate. In all likelihood, your client has come to you well after 30 days after the date of death. Don't stress. I don't remember one instance where a client has satisfied this requirement to lodge it within 30 days of death. But do it as soon as you're able to, and as soon as you get a copy of that will. And don't give it to your messenger service to deliver to the court. We made that mistake once, and that did not turn out well. Have the client hand deliver it himself or herself. Can you question from Kristen? Can you recap assessing the safe deposit box without letters? What section is that in the probate code? If you look at the first page of our outline, it's probate code 331. I don't recall the procedure off the top of my head, but if you look at that statute, and we can pull it up if we have time at the end of this presentation, and we can walk through the process. And I was listening to the presentation of the prior person, and he referenced the CEB secondary sources. Without a doubt, that is the best secondary source for estate administration in California. So that has substantial authority on accessing safe deposit boxes. So you want to take a look there as well. Okay, so assuming you have the original will, you lodge it with the court. They give you a receipt. If you do have a will, then the proceedings are called testate. And if you don't have a will, then the proceedings are called intestate or intestacy, which means you're proceeding as though the decedent had no will, and California's intestacy statutes would govern who receives the decedent's assets. Next, and we'll go into what happens if you don't have the original will. That's coming up, because in a lot of cases you don't. Next, you want to gather information about the assets and liabilities, get copies of the latest financial records to figure out how they're titled, investment accounts, brokerage accounts. Of course, get the addresses of real property, call your title agent, get the latest deeds on title. What you want to see in order to qualify for estate administration is the decedent's name on title alone, not with joint tenancy with someone else. Because if that person is still living, that person receives the asset and that property is not subject to probate.
With that said, obviously, a decedent can co-own property along with other people and co-tenants in common.
That's right.
So I think the takeaway is you obviously want to get copies of the deeds, figure out what title looks like, because that will inform, the extent to which the property is owned by an estate or potentially third parties, as Sean mentioned.
Exactly. And even if you are aware of assets that are in joint tenancy or have beneficiary designations, which would not pass through probate, you'd still want to gather that information from your client so that you have a global picture of all the assets, because it could affect filing of income tax returns if the estate is large enough, estate tax returns, and it would really, it would give you the opportunity to give your client advice regarding their management of the entire estate. So, if there's no cash in the probate estate, but there's cash outside of the probate estate, then you don't have to worry about liquidity concerns and things of that nature. So it's very important to have an understanding of all the probate and non-probate assets. Next slide, please. The heirs and beneficiaries, of course. Probate code 6400 identifies who would receive the assets of the decedent if he or she were to die intestate. So even if the decedent had a will, the heirs at law are entitled to notice. And the rationale for that is the will may be a product of undue influence and incompetency. It may be an invalid document, and the heirs would have standing to file a will contest. So the court requires that heirs regardless of the status of them being named as beneficiaries as well, to get notice. Others who would need to get a notice are beneficiaries and trustees named in the document. Kathleen has a question. How do you manage digital assets? A Facebook account, email account, web domain someone may own. How do you determine who owns the property if only ownership document in the email is used to open the account? Go ahead. So there's a very, I don't have the answer to this off the top of my head. There's a section in the probate code that's been recently released a few years back that deals with specifically the management of digital assets. And I know the social media companies have been mindful to come out with policies and procedures for accessing those accounts and allowing decedents to fill in whether they want anyone to have access to their social media accounts subsequent to their passing. So that's where you should start, is always with the social media company themselves to see if the decedent has filled out a specific form allowing or disallowing their successor in interest to access that account. Some people don't want family members to go poking in and around their social media accounts. It's not really an asset of value that passes on. So I've had situations where we have not been able to access emails or social media accounts, and these companies are very strict on disclosing that information.
Yeah, very quickly, because we are pressed for time. I think maybe we should hold most of the questions till the end just so we can get through this. With regard to domain names, those can be very valuable. Obviously, that's an asset. Those should be registered to someone's name more often than not. You can typically contact the company and get that information, especially after you're appointed and you have letters and authority to act on behalf of the decedent. We've done that on several cases without problem.
We actually sold a domain name, a 3-letter domain name in one of our estates. Substantial
Worth quite a
value.
bit.
Yeah. I'm short on time. Okay, I'm gonna start moving through this because we only have 30 minutes total. So the forms that are required to start probate are listed on the slideshow and in the material. The petition for probate Roe is going to go over in some detail. Then how do you determine whether a probate administration is even required? Slide 9, please. First, if the assets that are subject to probate, no, that's right.
That's right.
Yep. If the assets that are subject to probate, so all assets that are not joint tenancy, that don't have beneficiary designations, are less than 166,000, whether they're personal property or real property, in all likelihood, there's going to be a procedure for collecting those assets without having to initiate a formal procedure. One of those available options is the use of a small estate affidavit. Small estate affidavit, it's a form that you Google and you can fill out, and you wait 40 days after the decedent died, sign it, present it to the financial institution. So long as the assets in that account are less than 166,000, the bank will release it to you. And then there's 2 court procedures for transferring real estate that's less than 166,000. One of which is if the property is less than 55,000. Good luck having that happen in California. And then the other one is if the real estate is valued less than 166,000. Also a low amount, but we have used that several times, particularly if the decedent died a long time ago and it's the value as of the date of death, not today's value. Or if the decedent had a very small percentage interest in a piece of real property.
Vacant lots also tend to be worth less for obvious reasons. And so sometimes that comes up when you have vacant lots.
Yep. And really one of the most powerful tools to avoid probate altogether is the spousal property petition. And this allows surviving spouses to collect not only the inheritance that they're entitled to from the decedent, but also to confirm that an asset that's titled in the decedent truly is their property. So if an asset was acquired with community funds, they can say, well, wait a minute, it shouldn't be in the decedent's name. It should be 50% his, 50% mine. I'm filing a spousal property petition to confirm my 50% and collect whatever the decedent wanted me to have from his 50%. And there's no limits on spousal property petitions. Gotta hurry. And then, of course, if the assets exceed those thresholds, it'll be 160. You'll require a formal petition for probate in the state administration proceeding. I'm going to jump forward a little bit because we are running short on time. Slide 11 on types of wills. Different kinds of wills that you should be mindful of. One is a printed will with just the decedent's signature. That is what we like to call an attested will or a witnessed will. That must be signed by the decedent and witnessed by 2 disinterested parties. The second type of will is a holographic will, and that is a document that is where the material terms are in the handwriting of the decedent. So not all of the terms need to be in the decedent's handwriting, just the material terms, and the decedent's signature must appear. No witnesses are required, no notarization are required. I've even seen statutory forms that are fill in the blank, where the decedent has filled in all the names and amounts, and they have, the court has considered that holographic because the material terms are in the handwriting of the decedent. And then the lost or destroyed will, I definitely want to discuss, because when you're unable to track down the original will, there is a statute and a presumption that applies, 6124 of the Probate Code, that states that if you can't find the original and it was last seen in the decedent's possession, it's presumed that the decedent destroyed it. So you have to overcome that presumption by filing a declaration from someone who has personal knowledge as to, hey, the decedent truly wanted this document to constitute his or her last will, and the presumption should be overcome because of reasons A, B, and C. Absent objections, those are routinely granted. Courts are aware that originals are often not found. Initial petition.
Let's dive in. The part you guys have all been waiting for. Thankfully, we have some great exhibits attached here. So if you turn to Exhibit 1, you guys can follow along. We've given you a sample initial petition for probate, and you can track as we're going through this. I'll take you through it. With regard to timeline, that's the first thing we have here. A petition for probate can really be filed at any time pursuant to Probate Code 8000. As Sean noted, there is a rule that says that the executor has to file the will, lodge the will rather, and file a petition for probate within 30 days of death, or they can technically waive their right to act as an executor, absent a showing of good cause. That's something that I think is rarely enforced by courts in my experience. I think courts are rather understanding of the fact that most people are not aware of that rule. They're grieving following the death of a loved one. And so I would say that that is rarely invoked. However, it is something that you should be aware of. If you turn to Exhibit 1, we can just start from the top. Obviously, below the caption section, you're going to see a little series of check boxes where it says Petition For. First box is for the petition for probate of will and for letters testamentary. As Sean noted earlier, that's where you have a will. If you do not have the original will, you can check the second box in that column, which says Petition for lost will and for letters testamentary. That would be for a circumstance where you don't have the original, but you have a copy. And as Sean noted, that's going to impose additional procedural requirements on any party petitioning to overcome a lost will presumption. The second box here says Petition for probate of will and for letters of administration with will annexed. That applies in a circumstance where you have a will that designates an executor and you are petitioning for the appointment other than someone named as executor in the will, or where you have a will that does not name any executor. Again, if you don't have the original will, you need to check that box that says lost will. Letters of administration is the next category. That is applicable in circumstances where there is no will and you're seeking to appoint an administrator of an intestate estate. The box below that is for letters of special administration. Now, special administration is distinct because a special administrator is appointed for a limited duration of time and oftentimes with limited specified powers. So there are a number of times where maybe you can't wait for a court to adjudicate a petition for probate filed on regular notice because there's some sort of emergency and you need someone to be appointed to act on behalf of an estate. We've listed some examples in the outline. For example, when there's an exigency, as I mentioned, maybe there's some urgent estate business that needs to be handled that can't wait for a court to adjudicate a petition for probate on a regularly noticed petition. Maybe there's a circumstance where estate property could be lost if someone doesn't step in and act. There could be decisions that need to be made with regard to a decedent's body or funeral arrangements, which are typically time sensitive, or when the decedent is involved in pending litigation, where a decedent is either a plaintiff or a defendant in another litigation, and that court is not going to sit around and wait interminably for the probate court to appoint someone as either an administrator or an executor. It may be appropriate to go in and seek the appointment of a special administrator for the purpose of substituting into that action on behalf of the decedent. The next section is fairly critical. This is where we go through the distinction between full authority under the IAEA, the Independent Administration of Estates Act, and limited authority. Full authority, as the name implies, gives you all of the powers under IAEA. The most important distinction here is with regard to estate real estate. You have full authority under IAEA. You can sell real estate with what's called a notice of proposed action, something we'll discuss later. You do not need to petition the court prior to sale for approval. With limited authority, you do need prior court approval for selling real estate, borrowing against estate real estate, and granting options as to estate real estate. The bond may be lower in circumstances where you have limited authority, because where the court knows that you cannot sell or encumber real estate absent a prior court order, they may not require you to be bonded for the full value of those real estate assets. Moving on to bond requirements, which you'll see in item 2D. If no bond is required, there's a box there which says bond should not be required for the reasons stated in item 3E, that box should be checked. Certain circumstances where a bond may not be required are where the will waives bond. However, there are counties that, notwithstanding a will that waives bond, a court will require a bond if they feel that it is necessary to protect the estate, or in certain circumstances where the proposed executor resides outside of California or the proposed administrator resides outside of California, a court may impose a bond even though the will waives bond. If the beneficiaries all waive bond in writing, and you file bond waivers with the court has discretion to waive bond. But again, you really want to consult local rules there, because every court treats bond waivers differently. Some courts, notwithstanding the fact that all beneficiaries have waived bond, will still require bond under certain circumstances. 3
minutes.
Let's jump ahead. I think since we've covered bonds, there's quite a bit to talk about there. If we move to blocked account, this is a good alternative to bonds. If a court knows that assets from the estate are going to be deposited into account and that they can't be withdrawn absent court order, the court may dispense with a bond, the value of those assets. Priority of appointment. If there is no one named in the will as an executor, the court is going to look to statutory authority to determine a priority of who can be appointed to act on behalf of an estate. And as you'll see here on the slide, there's a statutory order of priority. Heirs are able to nominate people to act on their behalf. If they do nominate another person to act on behalf, the court is going to alter its priority. If the person nominating is a spouse, is a partner, a domestic partner, a child, a grandchild, things of that nature, the nominee takes priority behind all of the people in the category of the person nominating. If you look at item 5 in the petition for probate, that's where you need to identify all family members of the decedent. It's fairly self-explanatory. Items 6 and 7 follow the same path. You just check the boxes as appropriate, depending on the relationships of the various persons living to the decedent. Let's see. We can skip to notice in paragraph 8. Notice is going to track boxes 5, 6, and 7, where you identify the family members of the decedent. You have to give notice to all the decedent's heirs at law. In other words, all the people that would inherit from the decedent if the decedent passed away, subject to the laws of intestacy, as well as all of the people named in the will. It's great practice to review the will very carefully and make sure that everyone referenced in the will is named there. If it's a pour-over will, which directs the assets to a trust, you should also review the trust and make sure that all of the beneficiaries, all the people named in the trust are listed here. The last thing you want is a continuance for failure to give notice. Supporting documents. We've got a list here of supporting documents that you need to file along with the form numbers. Some of these are prescribed by local rules, such as the probate case cover sheet. The rest of the forms are all prescribed by the Judicial Council. They're required to be filed for all probates in California. We have a section here on the duties and liabilities form. I won't go through it. The outline summarizes the content. That's really a form that the proposed executor or administrator has to sign that advises them of the various aspects of the state administration, things for them to be aware about. We also have as Exhibit 3 a document called Notice of Petition to Administer Estate, which is something you're required to file 15 days prior to the hearing and serve on all interested parties. There's also a section here on publication. Publication in a newspaper of general circulation in the city in which the decedent passed away is required prior to the first hearing on your petition for probate. Good idea to get this going early because not every city, for example, has a newspaper in regular circulation that publishes every day, and you need to publish at least 3 times within 15 days before the hearing. You need to get started on that right away, because if you're in some remote county or a remote city that does not have paper in regular circulation, it may not be possible for you to get the publication requirements done in time unless you act quickly. There is a section here on probate notes. Brian already covered that in the last lecture. Prior to any hearing, in most counties, you'll have a probate attorney or a probate examiner publish notes on potential deficiencies. You need to review those before your hearing to make sure that all of those deficiencies can be cleared with a verified written supplement from your client. There is a section here on hearings. It's fairly self-explanatory. If the petition is all queued up and ready to be approved, the court can approve it. If there are objections, the court may continue the hearing to address those objections. Once the court does appoint your client as either an executor or an administrator, it's going to issue an order for probate, which confirms their appointment. And then ultimately will issue letters of authority, which are the formal document that describes the authority your client has received pursuant to the order of probate.
Good job, Rory. We have a few questions and only a couple minutes left, so let's tackle those. Stephanie asks, what do you do when a financial institution chooses not to honor the small estate affidavit? So Probate Code 13-100, I believe, are the relevant statutes. There's actually authority in the statutes that provide for that circumstance. You can petition the probate court for an order compelling the financial institution to release the funds, and the financial institution could be held responsible for the attorney's fees and costs associated with your client's efforts to get them to comply with their obligations. It's very rare in our experience, unless there's some kind of dispute among the beneficiaries or notice given to the bank that someone is contesting your small estate affidavit. Very rarely do they not honor it. I actually don't recall a time where they haven't. Joshua, yeah, Ray, you have something like that?
No. I was going to address Joshua's question. I think, this is a prime question when we're talking about application of a decision to, potential spousal property petition that we can probably discuss after the lecture. Unless, Sean, you want to opine on that right now?
Yeah, no,
because we're short on time, it probably requires a more expansive analysis. So we can give our email address as part of the chat. And this applies across the board to anyone. If you guys have any questions about the materials, especially because we had to rush through this because it's really a condensed schedule for a topic as big as this, you can feel free to reach out and we're happy to engage you in that conversation.
Yeah, Joshua, feel free to reach out to us and we can discuss the Wall's decision impact on the spousal property petitions.
Kathleen asks again, who decides whether you have full authority or limited? When you file this petition, you're going to make that election. Ultimately, it's going to depend on the court's determination. Some things that could get in the way of your being able to obtain full authority, I think most commonly it's a bond issue. When you have full authority, the court is going to typically require that you be bonded for everything that is listed in item 3D, right? So for all personal property, the value of all real property, all income derived from personal property and real property, it's not always the case that a client is going to be able to get bonded for the full amount. And so oftentimes it's a strategic decision to switch from full authority to limited authority as a way of helping your client get bonded, because that eliminates their need to get bonded for the value of real estate.
And one of the benefits of limited authority, and we do this a lot, we consult with our clients and we tell them, if you're selling real estate, one of the benefits of having limited authority is obviously a reduced bond, but court confirmation. Some people look at that as a detriment. You know, we look at it as a positive thing, because the personal representative gets an offer, accepts an offer, subject to overbid at the courts. And very often we see potential buyers coming into the courts and overbidding at the hearing and the property selling for more than what was contracted. So that's a potential benefit.
Joshua asks, is a pour-over will fully probated and subject to statutory fees? Yes, it is. And that's, you know, one of the reasons attorneys should always counsel their clients when they're doing estate planning to do whatever they can to fund their trusts before they pass. In the event you do have to have your pour-over will probated, it proceeds just like any other probate, and at the close of probate, the assets are distributed to the trustee of the decedent's trust. But it is subject to stat fees, statutory fees, extraordinary fees, if applicable, everything that would be included in a normal probate.
Grace.
With regard to notice of hearing with beneficiaries in another country, what is the best way to go about it? Email. If you have contacts with people with the heirs or other people entitled to notice in another country, the best practice is always to try to get them to accept service without going through the hassle, right, of having to do anything else.
And you do that by having them sign a consent form.
Correct.
But email service is not proper. So,
not sufficient by itself.
So email cannot be used. So it's petitions.
International mail.
Yeah, petitions for probate require mail. So you would just use international mail. And to the extent you can't locate someone, then there are different steps that you can take. So it's for another topic for another day, but you can reach out to us if you have any issues, if you're not able to serve an heir, and we can provide you some guidance.
It looks like we're out of time for this session. There is some more material in the outline about getting bonded, about submitting letters in order for probate, supporting documents. It's fairly self-explanatory if you review the outline. But again, if you guys have any questions, feel free to reach out to us as a resource. We're happy to address those.
And we'll be back in 15 minutes.
Michelle, we're going to go into the break, and we'll take up the next topic after the break.